Yes. Well, the Supreme Court is the last court of mistake, as we say in the legal palace. What they have decided today is now law. The Supreme Court has agreed with the High Court and the Court of Appeal that the Constitution of Kenya Amendment Bill 2020, famously known as the BBI Bill, is unconstitutional. And for that reason, ought to have been quashed, and they have agreed with the High Court and the Court of Appeal that that enterprise cannot go forth. For what reasons? Two grounds have been relied upon by the Supreme Court. First, that this process was not initiated by the people of Kenya as misrepresented. On the contrary, it was an enterprise by President Uhuru Muigai Kenyatta and his brother Raila Amolo Odinga. It cannot and it could not, for any practical purposes, have been a people-driven process. Number two, the Supreme Court has agreed with the High Court and the Court of Appeal that there was no public participation in the initiation and promotion of the BBI bill, because the participation of the people is a requirement anchored in the Constitution. And to the extent that that was missing, and in addition to the first ground, the BBI bill was unconstitutional.
Okay, so what's next?
What next is for us to implement the Constitution of Kenya as it is, because the Constitution of Kenya does not suffer the malady of adequate provision as to what is required to be done. The problem that has afflicted Kenya hitherto has been failure of implementation. And you cannot cure that failure by congregating a few individuals seeking to dismember and destroy the Constitution to allocate yourself offices so that you appease certain groups in Kenya. What is fundamental now, and to answer your question directly next, the people of Kenya should embark on rebuilding Kenya so that we restore the time that has been wasted. 4 years have been wasted. You remember the Big Four agenda has not seen the light of the day. Why? Because Uhuru Muigai Kenyatta abandoned the course that he had embarked to undertake, shook hands with Raila Amolo Odinga, thereby crippling effective parliamentary oversight and opposition, and to that extent failed the development agenda of the people of Kenya. So as we go towards the election, people must always take into account this fundamental fact that power belongs to the people, and this power needs to be exercised for the social, economic development of the people of Kenya.
Many say, just to wrap up, many say Njoki Ndong'o views on BBI, plus given the presidential petition, are radical. Do you agree with the judgment?
Well, let me prefix my statement. You've heard the Chief Justice lament that some of us seek to influence the decisions by what we say on social media and on TV. Let me tell the Chief Justice this. She must go and read the book by Lord Denning, a very distinguished judge. A judge has no business engaging people in the press on what they have said. A judge's function and duty ends in court. You write your judgment, go away. Let us critique your judgment. Let us evaluate objectively what you've done as a judge. Now, coming back to Njoki Ndong'o, it is our responsibility as advocates and the people of Kenya to abide by a decision of the court. Is she radical? I don't think she's radical. She has just expressed her own views based upon her examination of the facts, which she's entitled to come to that conclusion.
All right, Wakili, thank you very much.
Maybe a question, a last question.
Yes.
Because we've seen on a number of issues, there have been some form of disagreement on what was ruled in the High Court and the Court of Appeal, and now in the Supreme Court. Does it mean that in the legal system, at times you are reading from different scripts?
No, we are not reading from different scripts. You see, in the drawing of a judgment, many issues are considered. But in the final analysis, there's that which we call a determination. The determination that was made by the High Court was this, that the Constitution of Kenya Amendment Bill 2020 was unconstitutional. And for that reason, the High Court quashed it. For a number of issues which were lesser than those relied upon by the High Court, the Court of Appeal came to the same conclusion. Now, for two issues, the Supreme Court has come to the same conclusion. So it's not an issue where there is a contradictory perspective insofar as the questions analyzed are concerned. the convergence of this litigation, commencing with the High Court, progressing to the Court of Appeal, and now terminating with the Supreme Court, is this: the BBI bill is null and void. So this is what you should tell the people of Kenya.
Thank you very much.
Thanks so much.